The Ayr Harbour Trustees in the town of Ayr in Scotland were undertaking some upgrades to the harbour. The Harbour Improvement Project had its own legislation, and under that legislation, the Harbour Trustees were given a statutory power to compulsorily acquire land. Using this power, they acquired a small amount of waterfront land from a Mr. Oswald. The two parties fell into dispute about what the proper compensation should be for the area of land, and so an arbiter was appointed to decide the proper compensation. As part of the negotiations, the Harbour Trustees agreed that if Oswald stopped resisting the acquisition, they would agree to give him access to a road they intended to construct, and that they would not build warehouses on the land obstructing his view and access to the waterfront. They remained in dispute, and the proper amount to be paid ended up before the Court of Appeal. One of the things the court had to consider was whether the promise made by the Harbour Trustees to restrict their use of land was enforceable. They found that it was not. Lord Blackburn said, "I think that where the legislature confers powers on anybody to take lands compulsorily for a particular purpose, it is on the ground that the using of that land for that purpose will be for the public good. The powers confirmed on the body empowered to take the land compulsorily are entrusted to them and their successors to be used for the furtherance of that object which the legislature has thought sufficiently for the public good to justify it in entrusting them with such powers, and consequently that a contract purporting to bind them and their successors not to use those powers is void." In other words, by voluntarily restricting the potential use that it could make of the resumed land, the Harbour Trust was also potentially restricting its ability to undertake good works on behalf of the public, and this was not permitted. As a result, the promise made by the Harbour Trust was void, and the sale had to proceed as though they were obtaining the unrestricted right to do whatever they pleased with the subject land. From this case, we learn that a power to compulsorily acquire land is not to be read down or diminished, including by the agency itself.